Well, greetings and welcome to the last chapter, Chapter 51 in Business Law 2. Of course, this has been based off of the Business Law Texts and Cases, published by Clarkson and Mills, 15th edition. And this will complete the 51 chapters, these last 25 or so being in Business Law 2, and Business Law 1, of course, being the first 25. A little bit more general there. I hope you enjoyed the course. Have a few brief comments at the end, but again, I'll try to keep this right at about half an hour or so. So let's go ahead and jump into wills and trusts, because as I frequently tell my students, you're going to live a little bit longer after you're dead. And by that I mean that when you die, everything you own doesn't disappear. Other people will inherit this or take it, and this is a continuation of your influence, your life on the world. So wills and trusts can be very important pieces of this puzzle. So what is a will? A will is a legal document. It is the final declaration by a party concerning how they want to distribute their property after they die. So it handles both real property and personal property, although the real property certainly can pass in other ways, as can the personal property if we have a trust. A testator is a person who makes a will. Sometimes you'll hear the term testatrix as the female alternative testator, but it's really not necessary. It's a general term that describes both male and female. Testate means that you have died with a will, a valid will. You are said to die testate. If you die intestate, that means that you have died without a valid will. Maybe you never had a will in the first place, or maybe there was a problem with your will, we can't find your will, you die intestate, and there are going to be rules because your property still exists in this world even if you don't. And we've got to take care of that. The executor is the person who is appointed in your will to handle this distribution of your assets. Now, again, sometimes you'll see executrix for the female suffix. Administrator is the person that was the executor, typically in the will, has been confirmed as such by a court, usually a probate court, and now he's going to actually handle it. So the executor is the appointment. The administrator is the confirmation of this. Although even in the legal profession we do tend to use executor and not administrator as much, to be honest. Okay, laws governing will. Now I've already used the term probate, and I'm going to be talking a little bit about North Carolina and how North Carolina approaches it. But probate is the process whereby the will is carried out. So it's much like there are probate courts, like there are criminal courts. A probate court, and it can just be a judge, a regular old judge, or it can be a specific judge that just handles probate. But probate is the process by which your will is carried out. It is executed. It is supervised. Now, obviously, the administrator is going to handle it, but the clerk will keep an eye on him. Now, the American Bar Association has created, like it has for almost all the important fields, a uniform probate code. So this is an attempt to create a uniform body of law, which is, they've had reasonable success across the United States at getting different states to adopt this. Now, each state will vary its procedure, and particularly what's important is, can small estates, estates with assets under a certain amount, be handled informally? Now, North Carolina, I'm going to change this number right here. North Carolina actually recently has decided that anything under $20,000, depending upon whether we're talking married or unmarried, we can handle that informally. Sometimes it's called the poor man estate option. So once you get above that, if there's that amount of assets passing in the estate, well, then there can be probate costs and a little bit more supervision. Besides wills, of course, when you have a will, you are making a gift. Um, so we categorize those gifts inside the will with different names. So sometimes you'll hear the term legacy, but the preferred term is specific bequest. So if I wrote a will and I said, I want to leave my grandfather's pocket watch to my son Ben, that would be a specific bequest. Sometimes you're going to have a general bequest, which can be usually sometimes a percentage. So it can be something like I leave 20% of my estate in value to John Doe. Um, Abatement is a problem. Abatement is when we decide we're going to leave something to someone. Might be a specific bequest. I leave my watch to my son Ben, and then it's not in the estate. Maybe I sold the watch. Maybe the watch can't be found. This is said to be a problem. Now, if it's just a general bequest, usually you're going to receive a percentage of what you get. So if you were supposed to get $100,000 in a bequest, and there's only only half that amount in the estate, you're going to get 50%. Residuary gifts, which are pretty common, this is when you get whatever is left over. So very often you'll have a few specific bequests, and then you'll say, well, as the residuary of my estate, I leave everything to my spouse. In my case, it would be Shirley. A lapsed legacy is if someone can't take under the will, and one of the most common examples of this is that someone's dead already, or they can't be located. And in that case, it's going to generally pass to the heirs of that person, or it can go back inside the estate, depending upon how the will itself is worded. So what are the requirements for a valid will? Well, a valid will, first of all, the first requirement is you have to have testamentary capacity. If the will starts off, I, Dwayne the Fifth, Emperor of Nebraska, we've got a problem because apparently you've got some mental illness there. We don't require you to be perfect. We don't require you to have, an Einstein IQ or an understanding of the universe like Stephen Hawking's. We want you to have a basic understanding of what you have, and more importantly, who your natural heirs are, your children, your wives, or wife. The problems, of course, is we do sometimes see undue influence where people pressure people or trick people into changing their wills, or outright duress where they're threatened with physical force. If those can be proved, either parts of the will can be invalidated or all of the will can be invalidated. Now, in 99% of the cases, and it's probably a higher percentage than that, wills are written. In very rare cases, to pass only certain types of crime, you can have oral wills, a non-cupulative will, but that's very rare. Also, sometimes you'll see holographic wills, which are written out in the testator's hands, not typed and signed and witnessed. These are legal. They're a disaster to try to probate. Like I said, a holographic will, I remember I had a client who took some of those old school notebooks you might remember as a kid. They had a black and white, kind of looked like a cow's skin. And it was, she would write a will and then she would cross it out. And then she'd write another one and she'd cross it out every time she got mad at someone in her estate. When she died, this had to be probated. It could be done. It was holographic. They're valid in North Carolina, but it made for a very messy probate. As I said, there are non-cupulative wills where it's an oral will. They can only pass certain personal property. Technically, I've never seen one. They're very, very rare. All right, signatures. Each will must be signed by the testator, the person making it. Now, North Carolina requires that this attestation be witnessed by no less than 2 witnesses, and generally the preference is to go to 3. Even though it's a minimum of 2, it's a preference for 3, just in case there's a problem. Now, you don't have to get them notarized, but all good attorneys in North Carolina will. And let me quickly explain why. If you do not notarize the witnesses typically have to be produced, or evidence has to be introduced that they saw the signature and it was real. So they might be long gone. That might have been a secretary in a law firm 30 years ago, and you don't know where she is, and now she has to be produced in court to prove that, yes, that's her signature that recognized the deceased signature. If you notarize them, that's presumptive, so you can avoid that. Can witnesses have received something? Can they have an interest? Yes, but it can cause problems. Again, attorneys will generally tell you not to do that. Witnesses do not necessarily have to be of age. They don't necessarily have to be 18 or 25 or whatever number we want to pick, but they must be mentally competent. Now, some states require that an individual publishes his will, sometimes registers it. North Carolina does not. What about revoking will? How do you get rid of it? Well, if you take your original copy of the will and you physically destroy it intentionally, then that will is no longer valid. The other and probably more common way is to write a new will. So I have a will that I drafted when my children were very young. Now my children are of age. In my will would be a provision that while they were underage, if something happened, this person would have custody of the money to support them. Obviously that doesn't apply anymore, so what I could do is go draft a new will, or, and this is perhaps a little bit more common, we could draft what's called a codicil. A codicil is just something you amend to a will, you stick it on, and it changes some part of it. It says, okay, now that maybe I have another kid, or maybe my kids are of age, so I'm going to get rid of that section that says Aunt Gladys watches the money for him. Certain things will automatically change a will. These are operation of law. So for example, if my will said I leave everything to my wife, and she's no longer my wife, then she doesn't inherit under it if there's a divorce, for example, or death. An annulment, a birth of a child. If I say I leave everything to my children and I list them, but I use the term children and a later child is born, a later child is adopted, that child typically will take under the law. There are rights under a will. One of the things, and I know it makes for a lot of good drama on TV programs and stuff, is that sometimes you'll see someone written out of the will, a spouse. You can't really do that in North Carolina. In North Carolina, it used to be called dower and courtesy. We now call it elective share. If a spouse, there's a reading of the will and there's $1 million in the will and the spouse got nothing, that spouse, be it a man or woman, could simply say, I object to this will, and I'm going to take my elective share as opposed to what happens in the will. So there's $1 million in the will. Let's suppose there's 2 children, right? The children were going to split each. They were going to get $500,000. The wife says, nope, I'm going to take a third, since there's more than one heir. I'm going to take a third, so she takes $333,000 plus the first $10,000, so she gets $343,000, and the 2 children inherit $328,000 each, which is their percentage. So you can't disinherit a spouse. You can renounce it. You can call it disclaiming it if you don't want it. You can renounce your right to an elective share. And usually what people do is they'll take whatever is greater. There are a couple provisions that weren't talked about in your text. One of them that lawyers frequently write is what's called a simultaneous death clause. And this is something you got to watch out for if you get one of these home will kits. Make sure it's in there. And it usually will read something like this. In the event that someone in my will dies within 40 hours of my own death, I direct that they be treated as predeceasing me. Why is this important? It's important because that way if a husband and wife are in an accident, and typically what would have to happen is if the wife lived an hour later, okay, then the husband's estate would have to pay everything to her. That's one probate. Then the wife's estate would pay out to her heirs. So you can see how that's a problem. Now I actually saw this in a case where there was a husband and wife who had had previous children by other marriages. They died together, and there was not a simultaneous death clause, so it came down to who died first, because this is why it was important. So if the husband died first, all his money, which was hundreds of thousands of dollars, passed to the wife, and then since she was dead, it passed to her children. So all his money, at least initially, wound up going to her kids. If she died first, the reverse was true. So absent a simultaneous death clause, you can see how that would cause a problem. Informal estates can be handled at very minimal cost. As I said, North Carolina, there's a $20,000 that was raised recently. Standard. If the sole heir is the surviving spouse, if it's just being given to the husband or wife, it's only $30,000. Otherwise, probate costs in North Carolina will range somewhere between, depends how big the estate is, $2,000 and $10,000. Now, one of the things that can happen, and this is a pretty complex area of the law, is property can pass outside the will. Now, that's not necessarily a direct problem, but it can have tax consequences. So, if you owned, remember we talked about being tenants by the entirety or tenants in common or joint tenants, and some of those have surviving issues, a husband and wife, tenants by the entirety. If a husband dies owning land with his wife, it goes immediately to the wife, and vice versa. We also have living trusts. We also have life insurance, which can pass outside the will, and of course IRAs and 401ks, that should be included there as well. This can have some unexpected consequences. So, one of the things that goes on with estate planning is everybody takes a good look at what's going on outside. And sometimes there's very, very large amounts of money being transferred, but nothing's being transferred inside the will because people set up a living trust. Okay. However, sometimes it's certainly true that people don't have wills. So, if there's not a will, what happens? Well, the first thing that happens is any outstanding debts get paid. Now, that happens whether there's a will or not. So, if I owe money to the Visa or MasterCard, American Express, they're going to get their money first. And of course, the costs of administering the estate are borne. Now, generally, if there's no kids, the spouse gets everything. If there's no spouse, then it goes to the kids, then the grandkids. No grandkids, no kids, no spouse, it goes to the parents. Absent this, it goes to a non-lineal line, nephews, aunts. Now, I'm going to show you a chart in a little bit. You should remember, of course, that stepchildren do not, under intestate, generally inherit unless they've been adopted. Adopted children and illegitimate children are treated the same as regular children, and North Carolina is like that. Now, this is what's called the table of consanguinity. So if you'll look over there, you'll see the person. That's the person that dies. If the first way it goes is it goes down. So, all right, the first person that would inherit from me is my children. We're assuming there's no spouse. No children goes to grandchildren. No grandchildren goes to great-grandchildren. Now we're going to assume there's no great-great-grandchildren. Okay, if there's no one in that line, it goes to the parents. They're the next people. No parents, it goes to your brothers and sisters. No brothers and sisters, it goes to your nieces and nephews, grandnieces, grandnephews. No parents, no brothers and sisters, nobody down that line, goes up to grandparents. And you can see it goes further and further out. There's almost always someone we can find that is related to you somewhere down the pike that is going to inherit. Now, we do have this issue. Per Stirpes, I know it looks like it's per Stirpes, but it's per Stirpes and per capita. So I'm going to jump ahead to the next slide, which makes it a little bit clearer. So this is per Stirpes. Now notice if I left money to 3 children, okay, A dies, and they leave money to B, C, and D. If you say I want money divided according to generational lines on a per Stirpes basis, then C, who is my child, gets a third of the estate. So I had two other children. I had B and D. They each had one child. They had one child over here and two child over there. So there are three grandchildren. Under a per Stirpes division, each one of those grandchildren gets an equal share of the estate, 2/9. But suppose you said, no, I want you to take according to your successor, what's called a per capita by generation. So go over to the second side of this slide. In this case, A dies. He's got one living child still, C. Doesn't change it. C gets a third of the estate. However, D has one child. D's child, D1, takes the percentage that would have gone to D, gets a third. B has two children, B1, B2. They each get the percentage B would have gotten. So even though there's three grandchildren here, one grandchild gets a third of the estate. The other two grandchildren only get half that amount because they have to split what their parents got. And this is pretty much up to you to decide. Do you want to have your estate pass per Stirpes or per capita? And I generally recommend per Stirpes, but it's, again, something you have to explain to someone when you're doing their will. Okay, moving away from wills for a second, let's talk about trusts. And we had briefly mentioned this when we talked about antitrust law. But here we're talking about really personal trusts, not business trusts. So why would you set up a trust? Well, there can be good tax reasons. I'd refer to living trust. They become, or had become, very popular estate planning tools where people would put everything in these living trusts, which they could pull out if they needed. But the second they died, all the property went to their spouse, and it didn't have to go through probate. So what is a trust at its simplest level? Putting aside a living trust for a second. Well, you have a beneficiary. This is the party in the trust who gets the money. You have the trustee. This is the person that oversees how the money is distributed. You have the corpus, which is the body of the fund. It's how much money is in the trust. And delivery, how it's managed or set up. So those are the essential elements of trust. Most trusts are express trusts. People set them up. Now, I just referred to living trusts. These are set up for people that are doing estate planning. They put their assets in a living trust. The nice thing about them is you can revoke them at will if you want. Now, you can set them up to be irrevocable, but a living trust can be set up that if you need to get to that money, you just get to the money. Sometimes a trust is a testamentary trust. So let's suppose I had underage children or underage grandchildren. I wanted to make sure that they could go to college. In my will, I could say I direct that $10,000 be placed in trust, that would be the corpus, for my grandson Billy and my granddaughter Jane, and that be administered by, okay, sorry about that, bit of a dog issue there. And that it be administered by, and I would name someone to administer the trust, and it's usually a family member, or if it's a large enough trust and you have some concerns, it could very well be a professional. You have charitable trusts, which are designed to benefit the public. Now, they can last a little bit longer. Usually, there's something, I'm not going to go too far in this, called the rule against perpetuities. And what it says is that you can't set up most legal instruments that last longer than lives in being, everyone that's alive, plus 21 years. This means that we don't have dead people controlling all the money. There is one exception, big exception, which is a charitable trust. They can last a little bit longer. So famously, Ben Franklin set up a trust way back in the 1700s with a fair amount of money, and over compounding interest, it allows, I think it's a scholarship fund for tradesmen. We also have spendthrift trusts. You'll sometimes hear that, and you do that if you've got someone you're afraid is going to go through all the money. You limit how they can get to the money. It's a pretty common trust as well. A Totten Trust, you don't see much of this. This is set up with a bank account. These used to be a little bit more common. It's in their name, but you say in trust for another. It's basically a revocable trust, a living trust. As I said, not used very often. Implied trusts, sometimes we're going to set them up and it's going to be implied by law that we have them, and constructive trust. So we might set it up because it's just the best way we can do it. Sometimes a court will decide that that's the way we should set it up. Um, Trustee, let's talk about this person. This is the person holding the trust for the benefit of another. Now, it can be a court appointed, or if you're setting up a trust for someone, you can decide who it is. So it would be very common if a parent um, said, I'm going to set up if my spouse predeceased me and I have underage children, I want my trustee to be, and then you would name someone. Maybe you'd name a sister or a brother, a father or a mother, someone to hold on to the money for your underage children until they became of age. So, what's their standard of care? Well, it's what a reasonable and prudent man would do. And one of the big things they have to do is keep records and accurate records. The powers of these trustees are defined by the trust. So, you might say they can invest this money in any reasonable way. That'd be very broad. Or you might say they can only invest this money in fidelity instruments, or they can only invest it in the stock market, or whatever. You could set whatever limits you want. Absent specific terms, state law starts to apply here, but usually trustees get very broad powers. Again, you have the principle of the corpus, and unless you want the trust to bleed out, to disappear over a while, you typically will set up limits like the beneficiary may receive only the income from the trust absent a necessity to invade for special circumstances. Usually trusts will terminate. So for example, if you set up for underage children, I'm going to set up this trust for my daughter Jane. When she becomes 21 years of age, the trust ends, she gets the money. You can specify a date. You can say this will terminate when she's 35 if you want, or you could say when my son on August 13th, 2084, he gets the money. You can set whatever date you want. Disability issues. We're going to talk a little bit about this because this is starting to bridge the gap here. You all, I'm sure, have heard the term power of attorney, and powers of attorneys are pretty common. So if you're in the military, it's pretty common that the military will say, well, you should prepare a power of attorney for your wife or your husband if you're going overseas. And that's going to give them the authority to sign legal documents while you're gone. Now you'll notice that a regular power of attorney, there's something interesting about it. If I gave my wife power of attorney to sign documents, and then I was in an automobile accident and was rendered incompetent, I was in a coma, she couldn't use that power of attorney. The usual, or what's called a general power of attorney, only is effective so long as the person granting it is still alive, still around, still competent. The second he's not, it disappears. That's why you have to have a specialized form called a durable power of attorney. And now these can be whether there's temporary or permanent incompetence or issues, but a durable power of attorney says in the event this person can't do these things, I'm trusting my wife, my husband, my significant other to take care of it. North Carolina has a statutory form. We usually call this the healthcare power of attorney, and this is effective even if the party is disabled, and that's in North Carolina General Statute. North Carolina also has a living will statute. We call it in North Carolina Declaration for Desire for Natural Death. Be careful, it's not really a will, and if the doctor doesn't want to follow it, you got to remove the doctor. You can't force him to do what's in the will. You can't order them not to do things. Now, will they usually, accept a do not resuscitate order? Sure, they will. But if they go ahead and resuscitate someone, even though there's a do not resuscitate, there's no cause of action. There's no cause of action for wrongful life. Medicare and Medicaid planning. Now, Medicaid, AID, is for people who are too poor to afford health insurance. Medicare is the health insurance we give to people over 65. Now, there can be instances where someone is not yet 65, they don't qualify for Medicare, but we need to plan to get them on Medicaid. And you have to remember that long-term care for people can be very expensive. It can easily be $60,000 a year. And Medicaid will pay for this, but only after the assets in your estate are drained out. So some people want to protect some of this money, and it's certainly okay to plan for this. There's a way that you can transfer some of the money in some ways, and this is a little bit beyond the scope of the course, but I thought it was important to touch on. But you have to really talk to a estate planning professional to do that if you've got an issue. All right. Last point to talk about in the course, then a few general summations. First of all, I get the question, well, do I have to worry about North Carolina taxes on my estate? And the answer there is no. North Carolina has eliminated all estate taxes, so that money is never taxed. There's also a great benefit in both federal and state taxes. Let's suppose you have an individual who 20 years ago bought Microsoft, or 30 years ago bought Microsoft at $1 a share, and he bought $1 million worth of Microsoft at $1 a share. And let's suppose that today Microsoft is worth $100 a share. So his $1 investment has gone to become worth $100 million. So he's sitting on that amount of money. Now, if he sold it today, he would pay capital gains. He would, let's just say, it's actually lower, but let's just say he'd pay 20%. He'd pay $20 million. But if he waits till he dies, so he dies today, we'll say today is January 1st, 2021. It's actually later, but his heirs will get those shares of Microsoft. And what is their value to them? What do they inherit it at? Do they inherit it at the $1 value so that if they sell it, capital gains is taxed? The answer there is no. They get the step-up value. So that the stepped-up value is the date of death. So if it's worth $100 when he dies, the heirs get that money, and that money has never been taxed. This is a common estate tool to pass unrealized capital gains down to people. Now, you notice that there's something intrinsically unfair about all of this, is that you're letting people avoid paying taxes that other people have to pay. And in fact, you're letting some income essentially never be taxed. In 2020, as of today, federally, if your estate is valued at $11.58 million or less, there's no federal tax, which is going to be 99.999% of cases. If you're a married couple and your estate is valued at $23.16 million, there's no tax. Generally, spouses will get great benefits. Beyond that, once we're over 23 million or so, your tax rate starts at 18% of inherited money, going to a high of 40%. It's almost never going to happen because anybody with $20 million has done estate planning. They've set up mechanisms, trusts. They've set up ways in which the estate tax can be avoided. So estate taxes simply don't draw in much money anymore. They did in the past, but they don't. Okay, that concludes the chapter, and it concludes Business Law 2. I hope you enjoyed this. I'm going to be revising some of the other notes in the future, but we got through all these chapters, and good luck on the final coming up. It will be comprehensive. It'll cover everything. And, of course, there is a study guide available for you inside the course. Well, I hope you enjoyed it. I certainly enjoyed teaching you all, and I will hopefully, after this COVID is over, get to see some of you live sometime. Good night.